Good evening, and I welcome all of you to this webinar on contract drafting. It's absolutely lovely, and I'm quite impressed to see people joining from such different backgrounds. I mean, there are law students here, and there are legal practitioners here, people who work in different companies, or even just people who don't have a law background, but just people who are curious to learn, to probably just know something about contract drafting. So it's very impressive, to have all of you here. So it might just sound a little repetitive to people who belong to this profession. It might, this might be a repetition for you, but I assume that there are a lot of you here who are not from this background, so who don't know exactly what a contract is. So let me just try to give you a small picture of, just how, basically what a contract is. It's interesting that all of us, knowingly or unknowingly, enter into a contract every day, right? Like, just to give you a small example, just imagine that you go to a shop, okay, to buy a dairy milk, right? And you purchase the dairy milk and you pay money in return. Okay. Now you and the shopkeeper has just entered into a contract, as simple as that sounds, but that's actually what a contract looks like. Now, depending on the complexity and the nature of transaction, we put these things on a piece of paper, you know. Why? Because see, I bought a dairy milk, I paid money for it, and the shopkeeper and I, as a buyer, me as a buyer and the shopkeeper as a seller, both of us have certain responsibilities to fulfill, certain obligations, right? And if I fulfill my responsibilities, he fulfills his obligations, it's a successful contract. Good to go. If I fail in performing my part or he fails in performing his part, that's when we lead to something called a breach or like a violation of contract, right? So just putting these complex things on a piece of paper is nothing but contract drafting. Okay. So just it's so simple. And people who belong to this profession, striving towards becoming confident and independent lawyers, for you, maybe these skills actually can add to being an asset, right? Now you see what I'm talking about, right? We have a mixture of all kinds of people actually being curious about this. So to set the tone of how we're going to go ahead with this is that, this contract drafting, which I just explained to you, um, has to include a lot of legalities into it. The way you draft your contract actually decides your transaction. It decides how much of you are, how much liability are you taking on your head, everything. So today we are going to be learning about these legalities, the provisions, that the essentials, that some amount of essential clauses that have to be put in a contract. And to walk us through this first hour, in the first hour of this webinar, we're going to be talking about these essentials. And to walk us through these essentials and learning the importance of it and how we actually draft it, we have someone special here. But before I introduce you to him, I'll also just quickly tell you what we do in the second half of the webinar. Like how when these skills become an asset for us, it's necessary that we get rewarded for it, right? So in the next half of the session, we'll actually see how these skills can be used and what are the simple ways in which we can actually get some fruits out of these skills that we get a hold on, right? And in the end, we have a small surprise for you. Not really a surprise, but I'll take you to a world where maybe it's a possibility that you can get a stronger hold over these skills after you understand that these skills are valuable. In this short span of 1.5 hours, we cannot go too much into depth of all the essentials, but we'll try to get a small trailer, like an overview in front of you, as efficiently and as smoothly as we can. And I'm sure that the speaker that we have for today is going to simplify this and make this journey very enjoyable. Hi, I am Akanksha Mishra. I'm an independent litigator, and I have also worked as a counsel for different corporate companies. So, indulging into contract drafting and scrutiny. Apart from that, I'm also involved with Lawctopus Law School right now. And today I have with me Advocate Gaurav Mohanty. Gaurav is a brilliant corporate lawyer. He works as a senior advocate with a top tier law firm, which is Sam. All of us know about Sam. So he works with Sam, and this is what he does right now. But even when he was in college, like he completed his graduation from Symbiosis Law School. He has been a gold medalist. He is a recipient of the Ram Malani Scholarship. The best outgoing student, best student in the undergraduate program. He's also won like different competitions on contract drafting and whatnot. I mean, he has been a star student throughout his educational career, and now as a professional, he not only just indulges into contract drafting, but being a litigator, also being in the dispute resolution team, he actually looks at the real legal enforceability of contracts in courts. So who better than Gaurav can actually walk us through this and let us know how contract drafting skills can help us. So without wasting any more time and without actually depriving you of him, let me just hand over there's no mic, but let me just hand over this position to Gaurav. Thank you so much, Gaurav, for doing this with us. And I welcome you officially to Lawctopus Law School's webinar. And over to you, Gaurav. Really looking forward to learning from you and having a great and engaging session with you.
Thank you so much, Akanksha. This introduction part of any lecture is such an ego boost on a weekend. It always feels good to start. Hi, guys. It's so good to see such an active audience today with us for this 1 hour long teaser of what this contract drafting course is going to be. So I'm a dispute resolution lawyer working with Sam. And at the very outset, I want to dispel this one myth that contract drafting is something which only transaction lawyers or lawyers who work with general corporate handle. That is not true. Being a dispute resolution lawyer over the last half decade, I have dealt with hundreds of litigations, all of which start from the breach of a contract. We are there at the juncture where every contract falls apart, and we have the task of convincing a judge that our interpretation of contract is the right one. And the judge behaves the same way we do whenever we read a software license agreement. He ignores the terms and conditions and just presses on I agree or not, depending on his mood. So that is what we are here to understand. How can we draft contracts in such a way that they, at the end, when the litmus test arrives, they are enforceable by the court of law, because that is the true test which a lawyer needs to ascribe to. Yeah. So drafting a contract has two aspects: substance and style. Okay. Style is something like formatting, tabulation, grammar, all of which are very important, but that is not something which we're going to get into right now. What we are going to go into is substance, the building blocks of a contract, right? I'm going to take you today through 5 clauses, which are some of the most important clauses, and teach you what are the things which transaction lawyers usually miss out when they're drafting this, especially because they just get a precedent from their seniors or they download a template from Google, right? And they just change the name of the parties rather than streamlining it to the business needs of their client. Yeah. So we're going to discuss this, but before I start, I just want to speak about one thing. The clauses which we're going to do today are by no way and no stretch of imagination the clauses, the only important clauses, right? Every clause is like a prescription for a patient that a doctor gives. It has to be streamlined as per the ailment, as per the needs of the client, right? So please think of this as a teaser. And if you have any questions, please feel free to write this in the Q&A box. So without further ado, I will try and, screen share my PowerPoint presentation. Okay, this is the first clause which we're going to deal with. Okay, it's called description of parties. Sounds like a very simple clause. I mean, imagine if I am entering into a contract with Akanksha If the contract can simply say the contract is entered into between Gaurav Mohanty, son of so and so, and Akanksha Mishra, daughter of so and so. So why is this clause so important? You know, and why am I devoting an entire slide to this? Yeah, we'll just get to this in a bit. Right. I hope you guys are aware of this wonderful actress and the character that she plays in the Marvel Universe, Black Widow. Yeah. If anyone has been following the news, Scarlett Johansson has taken on Disney in a suit where she has claimed that by releasing Black Widow into Hotstar rather than in the movie halls, they have deprived her of a significant share of profit. Because Scarlett Johansson's contract, like the contract which Shah Rukh Khan and Deepika Padukone are entering into these days, had a clause which stated that they will reduce their signing fee provided they were given a certain portion of the profits. The profits which is judged from the remuneration which theaters receive. You know, as you guys might be aware, the Netflix, Hotstar, these streaming services, they're very confidential about what are the earnings of different shows. So with Disney releasing Black Widow rather than in theaters on Hotstar, Scarlett Johansson claims that she was frauded of her legitimate earnings. Right? Sounds simple enough? Okay. Now, what has Disney claimed? Disney has filed a motion in the court stating that the court cannot listen to this. We have to go into an arbitration. There's an arbitration clause in the contract. Okay. Now, with arbitration, what happens is arbitration will be a confidential proceeding, and it will save Disney the PR nightmare that the suit of Scarlett Johansson is causing Disney. You know, and naturally, Scarlett Johansson wants the suit to be public so that there is a public eye on Disney and they are forced to settle. Get it? Now, here is the rub. The contract is between Scarlett Johansson and Marvel, Disney's subsidiary company, and not Disney. Okay? In the contract, it states that it will go something like the contract is between Scarlett Johansson, daughter of so-and-so, and Marvel Company Limited or Marvel Entertainment Limited. It does not include the parent company. And that is why Scarlett Johansson is claiming that I have an arbitration contract with Marvel, yes, but I am not going after Marvel, I'm going after Disney. And this is where a definition of a party clause becomes so important, describing who are the parties bound to a contract. I hope this is making a bit of sense. Yeah. So why is it important? It is important to decide the liability under the contract. Who are you really wanting to go after? You know, the competence of parties to enter into a contract. Let's say you are entering into a contract, like Lawctopus is entering into a contract with Symbiosis Law School, for example, okay, with the contract law department that, okay, Lawctopus is going to conduct some contract drafting classes, right? But the contract department or the law school might not have a separate legal entity, right? The legal entity might vest with Symbiosis International University. So, or a trust, depending on which school it is. And this is where it helps us to identify the parties which are there, who we want to go after in case if the suit falls. I hope this is making sense. I see a lot of people are raising hands. I will address all questions, you know, after I'm done with one clause so that it just allows a seamless transition of doubts and answers. Yeah. The third thing it helps us in is also determining exit options. Okay. For example, I have a very successful tapri business. Let's say I have a tiffin business. Okay. And during lockdown, a lot of MNCs and companies have contracted with me that I will send them tiffins. Right? Now, let's say somebody wants to purchase my business because they think that my tiffin business is a fantastic business option. But if my contract with these MNCs in my party name does not say that Gaurav Mohanty tiffin business, the term includes assignees and successors, then this party who buys my business will have to again enter into contracts with all these MNCs and all these companies, which is obviously a very bad option for them, because they will have to renegotiate terms, renegotiate prices, and that makes the purchase of my business an unviable option, right? Similarly, again, going with the Disney example. So Disney is a parent company of Marvel, but if they were to include Marvel Entertainment Limited in brackets, write that it in this term includes a parent company, this creates a joint and several liability issue. I understand there are a lot of law students who might not understand what joint and several liability means. It is basically, you not only go, the Scarlett Johansson would not only get an option of going after Marvel, but also Disney in the same contract. And Disney being a much bigger company, the damages which Scarlett Johansson could have claimed under the contract would have been a lot larger. Yeah. So this is where party clause becomes important. It is a path to collect if things go wrong. So what details are to be included? I've given a lot of gyan on party details that we speak about. So how do we exactly go after this? What are the details we require? In case of a natural person, let's say it's one of us who's entering into a contract, we speak about, okay, Gaurav Mohanty, son of so-and-so, where do I stay? And details of an Aadhaar card or PAN, something like that. That totally nails down who I am and my details. I've often seen that in certain contracts, people rely on passport as an identifying feature and include those details in the contract. But that is not advisable, because a passport, when it expires, you're issued a new number. It's not that the same number is regenerated, right? And this is where it differs from an Aadhaar card or a PAN card, where the number stays permanent. Does that make sense? Same thing goes for a company. A company, you can write the registered address, but the registered address can change. So the details you go when you write a company name is you go for that corporate identification number, or what is called a CIN, along with the registered address and any other details that might pin down which company this exactly is. Yeah. Third is a power of attorney holder. Now, for those law students who are not well aware with this concept, a power of attorney holder is basically when let's say I'm staying in the United States, okay, and I need somebody to purchase my property in Bombay. So I appoint Akanksha as my power of attorney holder. I give her the right to sign the sale agreement or the sale deed on my behalf. This is called power of attorney, where you allow somebody to represent you in a certain scenario. But there have been multiple cases where people falsely present themselves to be a power of attorney holder and enter into a contract to sell a certain piece of land, and turns out that they do not have the right at all to do that. I mean, if anyone has seen Bunty and Bubbly, you know that these actors try to sell the Taj Mahal, presenting a false power of attorney and selling that to innocent tourists. So that's why, to avoid such kind of an unpleasant development, whenever you're entering into a contract with someone who claims to be a power of attorney holder, you want them to have the certified copy of the document using which they're claiming that they are a holder to be annexed to the agreement. Or if it's a board resolution which appoints them to represent the company, we need to see the certified copy of this particular board resolution, and that should be annexed to the agreement, or the details of that should be mentioned in the party clause. I hope this is making some sense. Yeah. Similarly, when we come to trust, I'll put a sample clause here so that whatever I'm talking about does not feel too much like an abstract notion. But if you see here, it says A and B are trustees of, dash, let's say trustees of Symbiosis Law School. A trust formed under, you write the act under which it is formed. Generally, it is the Indian Trust Act. And you can put in other details, where the address is, or, who's representing, etc., etc. Same thing goes for a minor. I don't know if you can see the entire clause because it might be hidden by this box, but it says ABC, a minor acting through XYZ, his father and natural guardian. I'll tell you why this is very crucial. I don't know how many of you are aware of this picture. Okay, this picture is one of the most famous symbols of the band Nirvana, their album Nevermind. Okay, and just last month, this baby, who's grown to be around like 30 years old right now, has sued the brand, stating that the parents never gave him the release, never gave the band the release to take his picture and use it for promotional purpose. The contract was apparently with the baby, and the description of the party did not say that it was through a guardian. And now this person is suing Nirvana for like millions of dollars. So do you see how party clause is such a crucial clause, which is it's the starting point of a contract, and people often ignore it by just writing details, whatever they get from the client, without really understanding who are they actually entering into a contract with, and the different factors that they need to keep in mind while entering into a contract with this entity or person. So are there any questions right now?
So yes, Gaurav. Actually, Zahir is saying, please mention sections of the Indian contract too. So Zahir, it's a class on drafting. So we'll focus a little more on drafting, but I'm sure ki somewhere here and there, wherever it's relevant, Gaurav will walk you through few of the sections if possible. But mostly we're learning the language, so that's why we're focusing on the drafting. Great. So somebody's saying, Gaurav, you're explaining the concepts really well, so please continue. That was the answer to your question. Okay, now we have two questions, Gaurav, for you.
Yes, please go for it.
First of all, could you please just elaborate in brief about the successors and assignees part again?
Sure. Okay, so successors and assignees, what are these concepts? Okay, successors and assignees basically means in the event that something happens to me, okay, and let's say if I am incapacitated by some reason, including death, okay, I do not want that contract to become redundant. So I would want my legal successors to be able to enter this contract and enjoy whatever proceeds of the contract that I was receiving. Yeah. To give you an example, let's say Michael Jackson had entered into a bunch of contracts with record producers for royalties out of all the money his songs were making. But that contract included that his successors, once he dies, continue to receive that amount. And this is where successors becomes important. Similarly, on a slightly different footing is the concept of assignees, right? Like I give you the example of a tiffin business, but let me give you another example. Let's say, okay, Flipkart. Okay, now Flipkart was recently acquired, if you guys have been following the news, by Walmart. Now Flipkart must have thousands of contracts with vendors, allowing them to sell their products on their website. Yeah. But now that Flipkart has been acquired by a foreign entity, in this case Walmart, it does not mean that Walmart will again have to enter into a gazillion thousand contracts with these local vendors, because the original contract would have the term with Flipkart, where the term includes Flipkart's assignees and successors. And thereby Walmart just simply steps into the shoes of Flipkart rather than undergoing the difficult process of renegotiation and re-entering into these contracts. Does that make sense? Does that answer your doubt?
Yes, thanks for the explanation, Gaurav. Let's just address one last question, and then we can move to probably when we address the sample clauses, half of your doubts will be clear there only.
Mm-hmm.
Do we have to explain the functions of the company with which you're entering into contract also? That will also come in your sample clause.
So do you have to explain the functions of the company? Okay, so generally this is not description of parties clause. It is something which comes what we call recitals. Once we have defined what the parties are, when we've spoken about, okay, let's say Gaurav Mohanty so-and-so is entering into a contract with a company so-and-so. And then we say, whereas this company is involved in the business of, I don't know, selling shrimp or whatever the objective of the company is, that is something which we call recitals. It's not really called the party description clause. This is always
so we don't mention the functions in the description of party.
In the description, we don't mention it. Yeah.
We can move ahead, Gaurav.
as lawyers, we already make things very complicated. So, the simpler we make things, the easier it is for the reader. So now that we have seen weird babies chasing money bills, let's move on to the next clause, okay, which is the indemnification clause. Typically in the scenario of contract, like the way we are moving from one clause to another, indemnification clause actually comes a little later. But as I said, this is a teaser where we are just going through a few important clauses. So that's why I'm jumping here. Okay. Now, indemnification as a transaction lawyer, this is where all your deals are going to fall and break through. What is exactly indemnification? Okay. Let's say you have a club, okay, and you want some shiny, beamy rooftop installed, like beams installed, which reflect disco lights, okay, and you contract me to build them, okay. Now you're going to trust me that I'm doing a good job, but since you have a good lawyer, okay, who's vigilant, you're going to incorporate an indemnity clause, which is going to state that if there is any loss caused because of negligence in my work, let's say if the beam falls because of faulty construction and causes a lot of damage, then I will be responsible for all the damage that is caused because of this. Okay. Now this is a very simple example. So I'm going to take it up slightly a notch and bring it to the world of transaction. Again, I'm going to use the Walmart and Flipkart example. See, now Walmart, Flipkart was a huge company, right? It had spread its roots to villages, towns, cities, everywhere around India. So when Walmart was acquiring Flipkart, it was not possible for the company to analyze the risks of each and every contract. At some places, it had to take Flipkart for its word that Flipkart is an honest company, right? And at this point of time, however, Walmart will not take Flipkart for its word like a gentleman's agreement, because that is something which does not work anymore. So in that contract whereby Walmart acquires Flipkart, it would incorporate indemnity clauses, basically whatever representations Flipkart has made. Say, for example, that I have complied with all the licenses required under Indian law. There's nothing I'm doing which does not have a license. So Walmart is going to take Flipkart's word for it. However, the indemnity clause is going to say that in the future, if Walmart discovers that one of the licenses was not properly obtained by Flipkart, and because of which Walmart has to pay $1 million fine, then Walmart could recover this 1 million from Flipkart. Does this make sense? Because this is where indemnity clause comes into picture. It is a way to shift risk between parties, because it is not possible for us to fully capture the different compliances which the other party might be not complying with or might not be doing. It's really difficult. So this is where an indemnity comes into picture. It helps us secure all the representations we have made in the contract. I'll give you another example. Let's say I want to acquire a coffee shop. This has always been my dream to have a coffee shop of my own. And rather than build one, I decide to acquire my favorite one, which is around the corner. When I do that, okay, I put an indemnity clause which states that, okay, I'm buying it at the price which you're quoting it. However, if there is any fault that comes out later, from the representations that you have made, because you have represented to me that it's a beautiful coffee shop, it has all the licenses, and there is the coffee prices are it's all comparative, etc., etc. So I rely on that and I buy the coffee shop. Later on, how I realize that your coffee shop does not have a fire exit, okay, and because of which the BMC now has charged me a lot of fine, right? So in this case, I can recover that fine by enforcing this indemnity clause. Yeah. How is this different from a guarantee? Now, guarantee sounds something which is very similar to an indemnification clause, but to differentiate it in its essence, guarantee involves 3 parties, whereas indemnification is always a 2-party scene between both of us. Guarantee is something on the lines of, if Akanksha does not fulfill her obligations to Lawctopus, I will come in and compensate Lawctopus. It's like guarantee is a way of trust, where I'm saying that, no, I think Akanksha is doing a great job. In case she doesn't, Lawctopus, you can recover the money from me. So that is where a guarantee is different. It's a separate agreement in itself, whereas indemnification is more like a clause which we incorporate into any agreement. Yeah. This is a sample clause. Each party, in bracket, as an indemnifying party shall indemnify the other as an indemnified party against all losses arising out of any proceedings brought by the indemnified party or a third party arising out of the indemnifying party's breach of its obligations or representations or warranties, or willful misconduct, or gross negligence. Now, if you did not understand this, I don't blame you, because it's a very complicated worded clause, but it is a good clause. Okay, I'll just break it down for you so that it makes sense. Now let's see. It says each party. That means this is a double indemnification clause. Like, it's not from one party to another, it's from both parties to each other. Shall indemnify the other. Shall means it's a compulsory obligation. Okay. Indemnify the other, as I said, it flows from each other, right? Now let's see what they're indemnifying each other against. Against all losses arising out of any proceedings. So their indemnification is restricted. The scope is only with respect to any proceedings. Proceedings in this case generally mean litigations. Okay. Any proceedings brought by the indemnified party. By this, they mean the party who is protected. Okay. Arising out of the indemnifying parties, and they lay down the three actions which they seek protection from. Any breach of their obligation or warranty or representation, any willful misconduct. Let's say if I haven't told you that I owe this bank 1 crore rupees and I sell off my business to you. And once you acquire the business, you realize that, oh, there's a 1 crore loan. That is willful misconduct on my party by not representing this to you at the very outset. Or gross negligence. Like, let's say if if I do not have a fire exit, for example, and there is a fire that is caused, which leads to a lot of criminal and civil proceedings against me. So I can recover all the damages arising from that from you. Yeah. But now I'll give you a personal example. Okay. So I was very lucky this year that I have signed a contract for publishing a book with a leading publishing house. Okay. And the publishing house sent me a contract saying that, okay, we are going to buy your book, we are going to publish your book, we're going to pay you this much royalty. But there was an indemnification clause which they had put, which is a standard format. It goes something like this. The author indemnifies and holds harmless the publisher and its distributors, assignees, and licensees against all liabilities, including but not limited to any cost, expenses, and damages arising from any claim which, if sustained, would be a breach of the above warranties. So basically, I'm representing to the publishing house that my book is an original book and that it does not constitute any IP infringement, etc., etc. However, the wording here, it says all liabilities. Now, as a vigilant lawyer, I changed this, I modified this. What did I make it? It's the same clause. The author indemnifies harmless, blah, 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 against all proven liabilities in a court of law. Look at the difference here. It says all liabilities, proven liabilities in a court of law. Now, the difference here is very important to appreciate. All liabilities means, let's say I publish a book and certain organizations find it offensive and ban the book or burn the book, which causes a lot of PR damage to the publishing house. Okay, that will be covered by the first clause because it says all liabilities, but not by the clause which I sent them, because the liabilities which I seek to indemnify them is only when the liability is proven in a court of law. That is a long drawn procedure where the publishing house will have to file something in court and quantify its damage, which is very difficult in such a scenario. And this is how I protected my interests. Because if it was all liabilities, it is too widely worded. And this is where you as a lawyer will also protect your client's interest by certain words that restrict the scope of your risk exposure. Yeah. So the one tip which I can give you, this is actually for law students, I understand this might be a little advanced, but for practitioners, big companies often obtain insurance from insurance companies with respect to their indemnification clauses. So let's say Flipkart has given indemnity that, I have all the licenses, etc., etc. They have valued all these indemnities at say 1 crore. They will obtain a suitable insurance from an insurance company as well. Like, let's say if this indemnification clause is kicked in, then this insurance will cover it. So when you're dealing in these contractual clauses for big companies, make sure that their insurance clause is aligned with the exposure you're taking up in these contracts. Okay, I hope this clause made sense to you. Any doubts at this juncture, Akanksha?
I was thinking we can cover this dispute resolution and then address all the queries.
Perfect. All right. So, okay, here we come to the dispute resolution clause.
Also, just 1 second, Gaurav, we have a small request. If you could also use Hindi so that a lot of people can also understand. So if you could mix the language, it will be great for a few of our learners.
Absolutely. Done.
Thank you.
Okay. From what I've heard, हमारी हिंदी थोड़ी सी खराब है, so you'll have to bear with me and not judge. We again went to the starting. See, I'm a noob when it comes to these slides. Hang in there. Okay, dispute resolution clause. It's very ignored. This is, like, in my experience, the most ignored clause, and the reason why most parties end up fighting a lot. What is a dispute resolution clause? So every contract, you have to assume as a lawyer that it will end. I mean, you hope that it will all be la la land and that you guys will get the best out of the contract. But as lawyers, you have to envisage the risk that the parties might have a breakdown of communication between each other, or some breach might take place from one party or the another, and that parties will then end up in court, basically fighting each other. And at this point of time, it's important to capture the method in which they are going to fight. Yeah, like the way in a WWE ring, you have rules, the things you can't do and the things you can do. Similarly, we have to create a dispute resolution clause which best addresses our clients' concerns and needs. Okay. For law students, to tell you at the very outset, there are essentially 3 kinds of dispute resolution clauses. One is litigation. This is the default clause. Like, if you don't have any dispute resolution clause, it is assumed that it is a litigation. You will go to courts, which often is not the greatest of options for big corporates, because as we all know, there's a big judicial overlag in terms of pendency of cases. So it takes a lot of time for any case to be resolved. So the alternate to that is an arbitration procedure. Arbitrations are in that sense a lot faster, but they also, to be honest, in practical, they also end up in courts. But nonetheless, arbitration is faster at least getting through the first step. This is where both the parties agree to appoint a third person to decide the disputes between them. And since he's obviously focusing only on your dispute, things move a lot faster. Yeah. And third is mediation. Okay. Mediation, jaise, agar aap, you've seen family law, you've seen Jolly LLB for that matter, right? So mediation is something generally that happens when the parties have a decently, acha rishta between each other, like they are pally with each other. So they want to give talking a chance in that sense. So mediation is somewhere where they appoint a third person like arbitration, but he, rather than decide the dispute between these parties, helps both the parties at arriving at a conducive solution, right? A mediation generally, in my experience, I've never seen it work between companies, but when it comes to smaller scale disputes, I understand that it is very effective. So again, this is something which you have to judge depending on the client who comes and approaches. Okay. International arbitration, I just mentioned one word, that international arbitration is basically when your seat, like, it involves transnational parties. Let's say if you're having a contract with a company outside India, it automatically becomes an international arbitration, and the rules that apply to an international arbitration are again very different. I'm not going to deep dive into this because it's an entire session in itself, but this is what it is. But if you have any doubts, please feel free to ask. Okay. All right. the dispute resolution clause. So the three things which a dispute resolution clause needs to satisfy, one of them is the reasonable and proportionality test. What does this mean? I just spoke of how whenever you are drafting a dispute resolution clause, you have to take into account the concerns of your client. Okay, let's say your Disney's lawyer, okay, who have gazillions of contracts with graphic designers, with actors, with people who create the sets, so on and so forth, right? In this case, Disney would prefer an arbitration clause because that is a confidential proceeding that happens a lot faster, and that they have a select arbitrators that are that are experienced in handling these kind of disputes. Okay, and similarly, as I just said, like it has to be proportional. So if you think that you have a small company, your client is a small company, does not have the money to afford the arbitrator because arbitrators generally charge a lot, right? Then you would prefer just going for simple litigation. You will take that chance that yes, this might take a long time to resolve, but I'd rather place my hopes with the court rather than become bankrupt in that sense by paying off the arbitrators and again end up in court. So you have to tailor the dispute resolution clause depending on your client's needs. Yeah. Then we come to scope, seat, and confidentiality. Okay, I spoke about confidentiality already in the Disney example. Scope, sometimes, okay, actually I'm going to speak about if you have seen any insurance agreement, like take your dad's or your mother's insurance agreement. Okay, when you look at that policy, you will see that each insurance company has an arbitration clause. Okay, like this is their method of resolving the dispute. But if you read it carefully, and this is across all insurance companies, right? They will state that we will resolve disputes only on quantum of money with you through arbitration if we have admitted your claim. I'll explain that. So let's say the insurance company has admitted your claim, stating that, okay, the fire that destroyed your companies or warehouse, etc., is a legitimate fire. So you're entitled to recover money under the insurance. But the dispute is on the amount. Let's say you want 3 crores. Okay, but I, as an insurance company, I'm ready to just give you 1 crore. So the difference of these 2 crores can be settled only through arbitration. So here the insurance company has restricted that scope. Because if the insurance company rejects the claim, like says that I think that fire was caused by you, as we see in Bollywood movies, right? So if that is a scenario, then the recourse to someone whose claim the insurance company has rejected is to go to courts, because the arbitration clause's scope is limited to only quantum disputes. Yeah, and similarly in a lot of different contracts, in engineering contracts, technical contracts, usually people restrain the scope to specific disputes rather than any dispute under the sun. Make sense? Okay. Seat. Now again, this aspect applies mostly in cases of international arbitration, where let's say you love France, okay, and you're dealing with a French company, then you can make your seat of arbitration in Paris, even if though you're an Indian company. So what happens is when there's a dispute that emerges between both the parties, the dispute is ultimately decided by an arbitrator in Paris. And if there is any problem with the arbitration, you can't come to Indian courts then. I mean, you can, but as per the law of the seat, the courts which you're supposed to approach are the French courts. So that is where the seat becomes very important. It determines the locus, determines the point as to kahan ki courts will decide any issues relating to this arbitration. It sounds a little complex, yes, I completely understand that, but this is what it is. Again, once we delve more into this concept, I will tell you as to how a seat has proved very fatal when it comes to involvement of courts in a dispute resolution procedure. Okay, I'll take you through a sample clause. Okay. Every dispute arising out of this agreement shall be submitted to arbitration unless it is a technical dispute, which may be resolved by a technical expert appointed by the parties. What do you think in your mind? Do you think this is a well-drafted clause? Because it is not. Okay. If you see here, it says every dispute arising out of this agreement. Now, people, if let's say there's a dispute that happens between both of us, okay, and I say, yes, this is a dispute arising out of this agreement, and it should go to arbitration. You, on the other hand, might say, no, 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 this is related to this agreement. It does not arise out of the clauses of this agreement. It is connected to this agreement, but it's not really on point. And this is how he will get out of this arbitration clause and take you to court instead, where the proceedings will drag on for years and years. Right? So here I have restricted the scope way too much. Yeah. Then shall be submitted to arbitration unless it is a technical dispute which may be resolved by a technical expert. Who is deciding this technical dispute? How do you determine which dispute is technical? This again raises issues of ambiguity, where one party might claim this is a technical dispute and the other party might simply say, no, this is a legal dispute, right? Then we come to the fact of this word, maybe. Is this a binding obligation? It is not, because it uses the word may. So if there is a technical dispute, are parties supposed to go to the technical expert, or is this an option? How do you decide that? So again, if you see, this clause is very ambiguously worded, and it's not a good drafted clause. Yeah. Now let's move to another clause. All disputes arising out of or in connection with. This solves the problem which we had with the previous clause. With this agreement, shall be submitted. It makes it mandatory. It uses the word shall. Okay. To the International Court of Arbitration of the International Chamber of Commerce. It's basically a foreign arbitration. Okay. International arbitration. And shall be, again, use of the word shall, which makes it mandatory, finally settled under the rules of arbitration of the ICC by one or more arbitrators appointed in accordance with the said rules. Okay, again, a very well drafted clause. But if you note here, it says by one or more arbitrators. Why this ambiguity? Why would you not define whether it is one or three? Because naturally, a party who does not have the fund would prefer one, and the other party who wants to bury the other side with costs would say, no, I think it means three. Right? So again, while this looks like a well-drafted clause, it has a lot of flaws. This is something which we call a multi-tiered dispute resolution clause. Okay, this is very detailed and for good reason. It says any dispute, difference, or question. It involves everything now in respect of or relating to this agreement. Again, it covers all possible disputes that can arise in this agreement. Shall be first referred to the chief executive officers, so the CEOs of both parties. The CEOs shall make efforts to resolve the dispute by discussing between them and or by engaging other senior officials involved in the implementation of the agreement in their discussion. This is in effect a mediation clause of sort, the first portion, where it says that, okay, our companies have known each other for such a long time. So if there's a dispute, let our heads try and resolve it. Let's not immediately jump into an all-out war. It's like a parlay when it comes to Pirates of the Caribbean. It's that sort of a thing. But if the CEOs fail to arrive at an amicable solution within 30 days, it also puts a timeline on them so that it's definite that, okay, by this time, if the CEOs have not solved the dispute, then the dispute shall be referred to a mutually agreed sole arbitrator. See, it also determines the number of arbitrators, that is one. The arbitration proceedings shall be held in English at a venue in Mumbai. It also decides the location. That means if there is any dispute with respect to this agreement and you have to approach a court, you have to go to the Bombay High Court. Okay? Under the Arbitration and Conciliation Act 1996. The decision of the arbitrator shall be final and binding on the parties. I hope this makes sense. Yeah. So tip which I would like to give everyone when you're trying to draft an arbitration agreement or a dispute resolution clause is think about your business needs. What is the risk exposure? Are you okay with courts? Do you want to have a mediation between parties, or would you rather prefer a dispute resolution clause, arbitration clause? Any questions at this point of time, Akanksha?
Yes. First of all, thanks Gaurav for making it so simple for all of us.
Yeah.
Just let's address one question at this point. Do arbitration proceedings have to compulsorily be confidential, or do we have to specifically mention that these proceedings will be confidential in contract?
So generally, arbitration procedure, when you're going for a institutional arbitration, like say ICC or ICSID, these are by default confidential arbitrations, but it is always a good practice to mention that the arbitration proceedings would be confidential. In case if you do not want to disclose the amount which you might end up paying to the other side, it's always good to keep a confidentiality clause in your arbitration dispute resolution clause. Makes sense.
Okay. Also, just rewinding to our description of parties clause. So there's a common question that we've been getting. Why is it necessary to write the name of your parents? Why do we write the source? Even in companies, like why do we talk about the law? And in natural persons, why do we talk about son of, daughter of? Why is it necessary?
Right. So the idea is, unfortunately, there is a lot of impersonation that takes place, when it comes to contracts between individuals. Right. When people, let's say when you're trying to register an agreement as well with the governmental authority, it's not that they just rely on your passport size picture. They will ask you for your thumb impressions or your biometric data, or they will ask you for your Aadhaar card details and take a picture of you at their designated place. So by this, we ensure ourselves against the risk of misrepresentation or impersonation by another party. Before the Aadhaar card came about, the traditional way since the time of Greeks has been to identify a person using their father's name, and in our feminist world using the mother's name as the choices. It helps in tracing the person's identity, because, for example, my name Gaurav Mohanty unfortunately is a very common name in Odisha. So, but when it is connected to my father, it says Gaurav Mohanty, son of Gorachand Mohanty. My father's name is insanely unique. So it connects me, in that way, it keeps everything in one place. It figures out, okay, this is that individual. And, this is how it helps, especially when it comes to individuals. It's just a practice which we use. Now, just to add to that, now that son of and daughter of practice has slowly fallen away in terms of, because of the new identification methods that the government has come up with. So it is not necessary to always have son of or daughter of written, but it just it's a procedure that we've been following, and it is helpful, to be honest.
Okay, great. Let's just cover one last clause.
Yeah.
Gaurav, because of the paucity of time and it's necessary, these are complex clauses. So
Right.
I understand कि एक इतने short period of time में हम शायद बहुत ज़्यादा depth में जाके हर clauses को cover ना कर पाएं. तो हम एक last clause अभी cover करते हैं, but I'll ensure you कि ये इस तरीके की चीजें हम और ज़्यादा करते रहेंगे, and we will delve deeper into it. And हर clause को अच्छे से समझना is our priority, not going through a lot of clauses in one go. So let's move ahead, and at the end of this clause, we'll address one final 2-3 questions, and then we'll go ahead with our next part.
Done. Sounds good. All right, moving ahead. Okay, can you guys see my slide?
Yes, it's visible.
Okay. All right. So the next clause which we speak about is governing law and jurisdiction clause. Okay. Now, why is this important, especially when it comes to COVID times? Why is this so important? This is important in cases of when parties are situated at two different places. A contract between someone sitting in Bangalore and a contract with contracting with somebody in Delhi, or somebody in India dealing with somebody in UK. Okay, let's say a force majeure clause, which is a clause that states that because of a plague, I'm not able to comply with my obligation. The way India treats force majeure is very different from the way France or UK might treat force majeure. So defining what the governing law is in cases of parties situated at different places is extremely critical, right? But it's not that you can choose any law the way you want to out of your own desire or choice. It has to follow the rule of CPC, which is you cannot confer jurisdiction on a place which did not have jurisdiction in the first place. Okay, it's a maxim which courts will happily cite out to you. I'll explain what it means. Let's say you are a party who's based in Bangalore, okay, who's contracting with somebody in Delhi, and it's an IP intellectual property licensing agreement. Make sense? Now, that Bombay High Court has the best judges when it comes to intellectual property. So you say that, okay, the courts in Bombay will have jurisdiction. Even though Maharashtra has no connection with the agreement. The agreement is being performed in Delhi. The parties are only in Karnataka and Delhi. There's no connection. Ultimately, when you try and approach the Bombay High Court will say no, because I never had jurisdiction in the first place. The contract choice comes into picture, where the forum choice comes into picture when it needs to have a connection with the agreement. So in this example, which I gave you, you can choose either the Karnataka High Court or the Delhi High Court. You know, there are various factors that help in choosing which court needs to be the court which decides all your disputes. I'll just come to that in the next slide. But before that, even when it comes to international agreements, you're having an agreement with two different parties. My advice is always state that Indian laws will govern it, because you as a lawyer will have no clue as to how the French law or even the UK law on which our law is based on works, right? So always choose Indian laws, not only for this reason, but the other reason that our courts tend to strike down clauses which do not match with our law. So even if, let's say, you choose that the law governing this entire contract will be French law, and there's some dispute that takes place and France gives a decree in your favor, you will have to enforce that decree again when you come back to India. And then that will raise a host of objections. And the judges in India might not grasp the nuances of French law. So as a drafting tip, it is always recommended that, Mera Desh Mahan, always use your governing law. Yeah. Okay. So the factors that govern, should dictate what governing law or jurisdiction that you choose. Place where the agreement is executed. Okay. Like, let's say if you have executed the agreement in Bombay, then you might be able to give Bombay High Court the jurisdiction in the example I cited before. Place of performance. Let's say it covers multiple states, because of, let's say there's a licensing agreement of a software, which is also used in Odisha and Maharashtra. Right? In that way, 4 courts might have jurisdiction: Odisha High Court, Bombay High Court, Delhi High Court, and the Karnataka High Court. So in this case, rather than have a doubt as to which court do I go before, you can put it down stating that, okay, any dispute with respect to this will be exclusively taken to Bombay High Court. Yeah. Place of domicile, residence, or business of the parties. This is basically wherever you are. If you do not want to travel to Bombay, you want to be convenient in the place where you are situated, then you can give the jurisdiction to that court. The national character of companies and corporations involved in the transaction. I just spoke of this. Like in a transnational agreement, you go for the governing law where the company is situated in. And again, as a rule, always go for Indian law. Subject matter of the agreement. Okay, let's say an Indian company deals up with a Russian company for manufacturing arms in Maldives. It won't happen, but this is what it is. So you can, in that sense, choose which laws to apply. You can be Russian law, Indian law, or the law of Maldives, right? You can decide that. So this is where it helps. Yeah. Just take you quickly through the sample clauses. This agreement shall be governed by and construed in accordance with Indian laws. Simple and Sushil. It works perfectly, because if you see, yahan pe it says shall be. Shall be ka matlab hai ki this is mandatory. Always go for this word. Okay, do not write word like may, because it just makes it very ambiguous. Construed in accordance with Indian laws. अगर दो Indian parties है तो ये सब लिखने का जरूरत नहीं है, because it is natural that the Indian law is going to apply by default. If you have a foreign national involved or a foreign company involved, then this becomes very important to add. Second example, the parties agree to submit all their disputes in connection with this agreement to the exclusive jurisdiction of Singapore courts. ये clause हम बहुत देखते हैं with companies who we are entering into a contract with, where the arbitral tribunal is SIAC. As law students, you come up till your 5th year, you will realize that SIAC, Singapore, is a favored choice of dispute resolution by all international companies, right? Because it's very fast. So in that case, let's say if you have an arbitration in Singapore, you don't want Indian courts then to have jurisdiction, because it's going to be like back and forth. So then you place the exclusive jurisdiction in Singapore courts. Yeah. And as a practical tip, Singapore courts they have a lot of Indians in terms of senior counsels there and judges. So they're also very well aware of how Indian law works. So it's a favored choice when it comes to giving jurisdiction in an international scenario. Third, This agreement shall be governed exclusively by and interpreted, enforced, and construed in accordance with Indian laws, which laws shall be deemed proper laws of the agreement. The parties irrevocably submit to the jurisdiction of the Indian courts, whether having original or appellate jurisdiction in any suits, actions, or other proceedings. Okay, there is nothing wrong with this clause. But whatever this clause is stating, this clause states the same thing in a much simpler language. So it's not always the trick that you have to make a clause as wordy, as lengthy as possible. Simplicity is key. I hope this helps. Okay, coming to the last and final clause, termination clause, and the most important clause, and the clause which determines every dispute that takes place, the ones which I have handled. Okay, what does termination clause mean? Termination clause is basically when you want to end the contract. It can be for thousands of reasons. You got a better deal, you want to quit, you think the other company is trying to defraud you, so and so. Okay, so termination clause can be divided into two aspects. One, where we define events that cause the contract to end. Let's say I sign a contract with you that I will do this lecture for 1.5 hours. Okay. Now, after 1.5 hours, my performance is complete. Okay. And you have given me a certificate. So that is an event that causes the contract to come and end because it has been performed. The contract has expired in that sense. So that includes automatic termination. The second is out of one's own choice. For example, I come on to this lecture and let's say I'm not allowed to screen share. Akanksha is being really rude and not allowing me to screen share and is asking me to do the entire presentation by rote. I'm not happy with that. And I feel that she's breaching her obligations. So then I tell her, okay, you know what? I'm terminating this contract. I don't want to do this. Right? This right, which I exercise, needs to be captured as part of the contract between Akanksha and me. Because if I terminate the contract midway without that right in the contract, I'm committing a breach. Yeah, that makes sense. And that will give right to Akanksha to claim damages against me later on, which is a problem. I can't pay Akanksha any money. So events that can trigger a termination. बहुत सारे हैं, seriously. I mean, it includes death, insolvency, a deadlock. Let's say if you and I just can't decide how do we go about this one particular deal. Let's say I hired an interior design. Let's say I have hired Suzanne Khan. ठीक है, उसको बोला है कि मेरे घर को पेंटिंग करने के लिए do the interior designing of my house, and I've hired Gauri Khan to do the whole bed and linens using decor. But I do not like the taste at all. And there is no way we can go ahead because I just do not like the taste and they obviously refuse to budge. So in such a scenario, we reach a deadlock and my contract captures this, that if there's a deadlock, I am allowed to terminate the contract, right? So that helps. Revocation of government approval or change in law. Change in law is a clause that is often invoked in India because of the retrospective tax laws. If you guys know, with Vodafone, with Ken, what happens in India is Indian tax authorities realize much later कि अरे ये company तो बहुत smart बन रहा है and is taking away a lot of money and we do not have laws to capture this. So they come up with laws and tell that this law will apply 10 years in the past. Some sort of a time travel of laws, if you will. Okay. And this is how they try and capture that money which they had lost. Now this, obviously any foreign investor coming into India will not be happy because they're like, okay, your government is just trying to raid us of all our money. And this is called a change in law. If you see this point, change of law rendering agreement ineffective. So I use this clause and I terminate my contract stating that, you know what, I can't go on with this. And this has actually happened a lot with foreign MNCs in India. So you have to set out all these events which you can think of in your termination clause so that everything is covered. But it has to apply to your business needs. Let's say if I am entering into a contract with Suzanne Khan, I won't write change of law rendering agreement ineffective. Okay, because that would not really apply to me. Or revocation of government approval. This does not apply to me again. Okay? So you cherry pick the clauses which suit your business needs and accordingly draft the contract. Termination clause generally requires notice. We are not barbarians or savages. Yeah? There's a requirement of good faith. So every termination clause will have a notice period. like for example, if I want to quit my law firm, okay, it's not that I can just decide one day, you know what, I'm done with this, okay, and throw the papers around. That just happens in movies. Okay, you have to put in your papers and issue notice and serve a 1 month or a 3 month notice period, so that it allows smooth transition from one, like I am leaving and somebody replacing me. Same thing happens in every contract. However, some all these contracts also provide for events where a notice will not be required. You know, okay, let's say that I am renting this flat from a landlord, and I have a massive party here and the cops are called. Okay, the landlord will state that, okay, the agreement which both of us had clearly stated that if cops are involved in any way, he will have a right to throw me out the next day. You know, and this is where notice period is very important, and setting out details as to when the notice is not required is also critical. Yeah, but termination without notice, please note, that happens only in the gravest of situations. And the other way to also go about this is have a double, like, you know, we discussed multi-tier arbitration clause. We follow a double notice. What is a double notice? Okay, let's say you and I have a 10-year contract. Okay, ऐसा नहीं कि कुछ थोड़ा सा गड़बड़ हो गया and then I will say I'm terminating the contract. It is not conducive to either party, right? In such a scenario, I will give you a notice to remedy your breach. You know, I will tell you, ठीक है boss, I'm highlighting कि ये गड़बड़ आप कर रहे हो, ठीक है, आपके पास 2 महीना है इसको solve करने के, ठीक है. If you do not solve this within 2 months, then I will issue you a termination notice. So this is also incorporated as part of many contracts where they don't want termination to be very sudden. They want a chance to redeem themselves, to remedy the breach. Yeah. Again, this depends from business to business. In generally, this remedy period applies to big infrastructure contracts where a lot of things go wrong, you know, from time to time. So you can't have a ready termination at every event. So you have to provide notice to remedy breach. I hope it's making sense. Okay, how do I draft a termination clause? There are a lot of ways to draft, but you can actually use this template. Okay, the first one states that except as otherwise provided in this agreement, each party shall have the right to terminate this agreement by giving a 15-day prior written notice to the other in any of the following circumstances. And then you list down whatever circumstances you think are needed. So if you notice, it says prior written notice. Written is very important. Ye nahi ki somebody, because a lot of parties will take advantage if it just says prior notice and say that I told you over the phone call, you know, that I am terminating this contract. And will that count as notice? Might be. So why do you have the ambiguity? So you make sure you write written notice. You know, it makes sense. Similarly, the same termination clause can continue for non-notice periods. However, each party shall be entitled to terminate the agreement forthwith in the following circumstances. Like if the company has committed fraud or has cheated you of money or something on those lines. Yeah. Sample clauses. Okay. One, again, examples of that condensed into two. Either party may terminate this agreement upon a material breach of a provision of this agreement after giving a 30 days notice to the breaching party to cure such breach, and if such breach is being cured within the aforesaid period. I do not know what this contract clause means. It is so confusingly worded, so don't even try. Yeah, but this is a legitimate clause which I picked up from a contract that what I was litigating on. You know, it says either party may terminate. The obligations are weird. There's a dearth of punctuation marks which makes the sentence very confusing. So that is an example of a bad clause. Okay, this is a clause which, as law students, you must experience with all your landlords. The landlord shall have the right to terminate the lease at any time during the term of this agreement by giving a 30-day prior written notice to the tenant. It's very simple and it's a very standard clause. And it captures what the landlord needs, a 30-day notice period. He does not need a remedy period where he will give me time to remedy it. No, he doesn't care. He will just simply go for the next guy who gives him a better rent. Yeah, makes sense? Okay. Termination clause that's just not what termination clause is. Termination clause also needs to incorporate what happens after termination. Ye nahi ki, you know, thank you, now bye bye. You know, what happens to the obligations of the parties once termination takes place. You know, for example, if I have given you confidential information I'll give you an example. HBO signs up with Disney Hotstar, Hotstar for releasing Game of Thrones. Okay, and that agreement terminates, and that episode has not released yet. So, ये नहीं कि Hotstar will be allowed to cast or leak the Game of Thrones episode. It is Disney's lawyers, HBO's lawyers will have to incorporate that any confidential information, Hotstar will have to return it to HBO. So all these episodes which Star got, they will have to return it to HBO. So these kind of clauses are very crucial to incorporate in your contract, depending on your business needs. For example, non-solicitation of each other's employees or clients. Let's say some other company enters into a contract with Lawctopus for a shared presentation, and they think Akanksha is doing a great job. But ye nahi ki once the contract terminates, they will poach Akanksha. That is Lawctopus's loss, right? So we prevent that sort of a thing. Similarly, there's terms and time frame for disengagement of parties. Let's say we're building a big bridge, okay, which is halfway done. Okay. It can't be that, the moment the contract terminates, I'm expected to take away all my equipment from there in one day. It's impossible. So, and it's not that I can allow them fully 2-3 years to withdraw all their machines and equipment, right? So this is where the time frame and terms we decide. अच्छा ठीक है 6 महीने के अंदर आप धीरे-धीरे करके you will take away all your equipment and completely disappear from the site. Yeah. Survival of certain clauses of this agreement. Okay, this is very crucial. See, now let's say once the contract terminates. Okay, like the Suzanne Khan example. Let's say Suzanne Khan has designed my house and it is beautiful. Okay. Contract is done because she has performed her contract and she leaves. The contract is terminated. Now I find out that the carpet she used, which she claimed was from, Lebanon, turns out that it was right from Bombay's Chor Bazaar. Okay, now that offends me. That definitely is a breach of agreement, but the contract is terminated. What do I do? This is why it is important to make sure certain clauses, like the dispute resolution clause, survives even after the agreement is over. So once the agreement is terminated, you can still go after your interior designer and say, hey, what is this? You cheated me. Yeah, makes sense. Future restrictions from carrying out a competitive business in a specific territory for a specific period. Okay, this happens when, generally in lawyer, like the way I have joined a law firm, okay, and I'm doing a great job, okay. It should not be the case that I pick up whatever I've learned from my law firm and go and start my own law firm within the next 30 days, steal all the clients and, enter into a competitive business with them. That will be a loss for my law firm. So that's why they incorporate certain reasonable restrictions so that I don't take advantage of whatever I've learned from them. Yeah, makes sense? Okay, this is a sample clause upon expiry or termination. This is basically a survival clause. Okay, upon expiry or termination of this agreement for any reason whatsoever, all relevant licenses and sub-licenses granted by the licensor to the licensee shall terminate automatically with effect from the date of such termination. It means at that date, the moment it expires, all the licenses expire. There is no time period given. That day, it's all gone. Okay. Then it talks about the obligations. The licensee shall transfer, assign, and convey all its ownership of any beneficial interest in the technical know-how developed during the course of this agreement to the licensor without keeping any copies or reproductions thereof in any physical or virtual forms. It's, I know, a slightly wounded clause, but again, try and picture this from the perspective of HBO and Star. Okay, read this as such. Star will transfer and return the ownership of any interest in technical know-how Game of Thrones show during the course of this agreement without keeping any copies of that episode in any physical or virtual form. I hope this makes sense. Yeah. So the one tip to follow when it comes to termination clause is the what if game. I know I use a lot of Marvel terminologies, but this is what it is. Like, always picture a scenario. Okay, what if this goes wrong? What are the rights of my client, or what are the obligations of my client? Try and capture everything under the sun, because the more certain, the more definite your agreement is, the more protected your client will be once things go south. Quickly, I'll take you through this because of shortage of time. The things which you need to keep in mind while you're drafting a contract, or for law students taking part in a contract drafting competition. avoid the copy paste syndrome. See, even as a lawyer, we also get templates from our seniors or from the web, but don't blindly just change the party names. Look at every clause and see how you can tailor fit it like Harvey Specter to your business needs. Okay. Use active voice, the agreement shall, that sort of a thing. Do not use passive voice, because passive voice creates a lot of ambiguity, and each party thinks that they're understanding something differently. Okay. This sounds very cliche and corny, but remember that your client is a universe. Okay. Think from his perspective, not just as a third party lawyer. Okay. Connected with this is know your business. Know the risk exposures that you have. This will help you in determining what your indemnity clause is going to be, which should you choose, arbitration or mediation, and use these risks to negotiate well. Because a lawyer's job is all about negotiating, knowing these factors and entering into the contract. So when you're sitting across your rival lawyer on the table, deciding which clauses to put in the contract, which clauses to not, the knowledge of your business will help you in being from being taken for a ride with the other side lawyer, right? It's all a war. And think about your reader. This is very critical. See, nobody likes reading a contract. It's a true story. Okay, they are very boring. Okay, but when you're coming to a deal, when you're trying to get that person to acquire your business, now India's market is booming and they are getting all these foreign investors. You need to think about those people reading it. If you make your contract language simple and less convoluted, it will create a positive atmosphere, which will help you in your negotiation skills. If you knowingly make it very confusingly worded, it will create an impression of distrust, create an atmosphere of distrust and suspicion, which is not conducive to the negotiations which you're doing on behalf of your client. Yeah. So I hope this brief teaser has helped you. I will leave it to Akanksha now to take it forward from that. But please, if there are any doubts, please feel free to ask.
Yes, thank you, Gaurav. I think you can stop sharing your screen also. And let's just address some common question. Just on a lighter note, which book would you recommend is best for contract drafting and also for corporate law in general?
Which book? Oh, those are very different stuff, because see, okay, one thing, corporate law is, there's nothing called corporate law per se. It involves a gazillion babies. You have project finance, banking. What book I would recommend when you're in law school is the book which your principal has recommended or your director has recommended, because if you know that one book by heart, it's perfect. So it's not that. And when it comes to contract drafting as well, it's more about practice, because once you graduate out of law school, you will realize that academic knowledge will help you till a certain way, but contract drafting, as I said, it's all about substance and style, which comes from practice. I don't want to repeat that cliche adage, but practice makes perfect. So take part in contract drafting competitions and develop and hone that skill, and really help you. Or look at the contracts which you sign up for. Next time when you're downloading an app from Play Store, don't just skip to the I agree portion. Look at what dispute resolution clauses there, what kind of indemnity have they put, and then you will start training your mind to appreciate. Okay, I see what the lawyer is up to here. That's how you develop that mindset.
Okay, lovely. Also, Gaurav, could you tell us what are the reasons and what are the situations in which a termination of contract happens without notice?
Okay, so I just spoke about those, that one particular slide where I had set out events. Let's say you discover that the company with which you were entered into a contract, the director turns out to be Nirav Modi, okay, who has absconded from India after defrauding a lot of people in terms of the LOUs and LCs. You don't want to be associated with that company anymore, right? So you immediately terminate the contract without notice. And your contract will have that clause that if the other country is guilty of some criminal breach or is convicted under law, you're allowed to terminate the contract at the very outset. So in that sort of a scene, it does help.
Okay, great. So we still have a lot of questions, but let's just quickly move on to the second part of our session. We've already I understand that we've overstressed a little bit. Just let's just start covering the next part, and then we can come back to your questions in the end if time permits us. So yes, now that Gaurav has actually stayed such a great foundation for how a contract drafting and what these skills can do, what these skills can do for us and how it's done. We've gone through 5 of the most complex clauses. So now let's figure out how 3 simple ways in which we can actually try to put these skills to use and get some reward out of it. So the first way, I'll try to keep it as brief as possible and understand this is just a small trailer. Okay, there's a lot that goes in depth into it, but let's just only cover it as an overview perspective. So the first thing that that actually can be very helpful is having a very good LinkedIn profile. So trust me that LinkedIn is actually a great stage to express what your skill sets are and what your experience is. But it's very important that on our LinkedIn profile, we only include specifically include the experience and the skill sets of the types of contracts or the types of or the nature of transactions that we want to engage into with our clients or prospective recruiters as well. एक बुफे में जाके अगर आप बहुत सारा खाना देखते हो तो you get confused and you want to eat everything. But if you are sure about what you want to eat, you look at that and then you eat it, you're able to easily grasp it as well, right? So that's what we do in the LinkedIn profile also. And trust me, it works. When you have an attractive LinkedIn profile, then moving ahead in the approaching the clients or the prospective recruiters really works. Okay. So the next portion that is that after you have a good LinkedIn profile, you need to, it's advisable to make a customized proposal in that regard. Say, for example, my expertise lies in, say, drafting of service level agreements or say employment agreements, or say my expertise lies in drafting of loan agreements. So that way, when I approach the clients, now how to approach, what to write, all of these things come in depth in the detail portion. But when we approach these clients or these companies or the even individuals for that matter, it's necessary that in the proposal you include all the services that can be of help to the prospective recruiters as well. Okay, so just one second. So the first step is it clear? Is it making sense that making the LinkedIn profile and including the specific skill sets and experience can actually let your recruiters and your clients to see and highlight what exactly your expertise is? Okay. Remember, approaching is a skill. Okay. I know that in the Advocates Act, lawyers are not allowed to advertise, right? But approaching and actually creating a stage for yourself is a skill which can be done with posture, and it can also be done by using the right words and the right language. And we will deal with that, whenever the depth comes in. Okay. Moving to the second and the most simple way is, remember that be it your room or a supermarket or a courtroom or a business, a company, anywhere you go, you are a lawyer everywhere, right? So it's very necessary that in general conversations that you have with people, you always remember that you have something to offer to them. So during a normal conversation, you can just try to understand more of the person's needs and just somewhere pitch in the middle saying, oh, hey, yeah, that's true, I can help you with that. Here's my business card, you can approach me. Depends on obviously the kind of relationship that you share with them. If you're talking to your friends, you don't have to be so formal. But most of the times, if you know how to sell yourself, I know I'm using this word, but when you know when to pitch in a very general conversation, people usually take it very people are usually, you never know, at that point, maybe they don't really need you, but trust me, at some point, you will always get to a point where they will look at their wallets and they will approach you. It has happened with me and it will definitely happen with you as well. So Vidhi, Vidhi is asking where to include this information on LinkedIn. So when I was talking to you about LinkedIn has a bio option, right? So you include your details in your bio in bullet points, something which has to be very specific to the point. Have a good professional picture. It's funny, but if you don't have a picture in your uniform, it works better. And you should also not have, I mean, it's said that there's difference of opinion, but if you don't have a picture in a lawyer's uniform, it works better. Okay. So that's about it for LinkedIn. Then having your customized business cards always help. See, there's this one thing that my mentor always told me, and I would like to pass it on to you as well, is that only you know where you are. Imagine if you're just starting your career, only you know that you are probably small today. The world doesn't need to know it. Okay. So if you have the professionalism, if you have the body language, and if just carry it with confidence that, okay, when you're talking to, say, your friends or your family members, you know that this is something that probably you can't do, but take it up regardless. Just tell them that you will do it, and you will find hundreds of people who can help you with that. Okay. Moving to the third simple way is, now imagine you're already working with a particular entity, okay, as a lawyer, and you're already providing certain services to them. Uh, Try to imagine and get into the depth of what all can be extracted out of that service as well. Okay, get into the highest potential of it. Let me give you an example. Now, imagine that you are a lawyer, you are a corporate lawyer, and you get a legal service to draft a contract for a company. Okay, say terms of a website. All right, you're supposed to draft the terms and conditions, the privacy policy, and the refund policy. Have we all seen it on a website? If you see any website, you will see some terms and conditions at the end of the website, right? That's also a contract, right? So imagine that you get a service of drafting these terms and conditions and these privacy policies. Now, what you do is you are drafting this for a particular company, right? Now you give an offer to that company. Say this company that you're drafting these terms are, this company is a software development company. They make websites for other people as well. Now, what you do to this company is you approach them and you say that, hey, I drafted these terms and conditions for you. I have an offer for you. Okay. How about when you are going to make websites for your prospective clients, how about you add an additional service, or say a legal service, and let's partner. I will draft the terms and conditions, privacy policy, and refund policy for your prospective clients as well. Simple. You can partner with that company, you can add a legal service into it, and then you can actually go ahead with your services. And with just one service, with this one company or one potential client, you have created a branch of a lot of different types of clients as well. Am I making sense? Is it too fast to understand? Could you please tell me on the chat box if I'm going too fast or if it's something that is not clear to you? All right. Okay. So this is the third way in which I know that actually the skill of making money is not something that can be taught per se, right? But just remembering the right things that has to be done, and remembering these, just bifurcating these three simple skills into delving deeper into these simple skills will actually get you to a position where you will be able to find your own ways to get the most out of these three ways. All right. I know this is since the duration of the webinar was quite short, we were not able to get into the depth of most of the things that it was, but the idea behind this webinar was to give you an idea, to give you a picture, a trailer of how things actually work out in a contract, how things work out in real life when you approach your clients. And this was the main aim of our webinar. Okay. Now, moving a little bit towards this, I can already see 80 to 83 questions that are coming up in the Q&A box. I know that we are not able to answer these questions today in this webinar, but let me take you to a small world, to a place, to a resource center where we could probably help you out better with your skills. Like so many of you have asked, questions on with respect to the clauses that we covered, also with respect to these ways of, like when I spoke about monetizing your skills, your questions were how to draft it, where to put the things in LinkedIn, who should I approach, everything. All of these things in detail can be covered through this one, like a resource. I would like to call it resource that we provide at Lawctopus. So I will be speaking a little bit about the contract drafting and negotiation course that we have at Lawctopus. So first of all, feel free to leave the session if this is of no use to you, but I would like to introduce you to this world where this drafting as an art or as a craft can actually be learned. I know it's not something that can be read in a book. You can't read a book and suddenly learn the practicalities of a particular art. Okay, but actually this course is designed in certain way that it gives you a very practical implementation. It gives you a practical approach of drafting a contract. So how many of you think that drafting a contract is actually a valuable skill set to have as a lawyer? Just how many, anybody who thinks that way can actually write yes in caps on the chat box, right? I always, thank you for that response. I always compare contract drafting to the skill of swimming, because I cannot read a book and then learn how to swim. I need to get into the pool. And what better than somebody actually just entering into the pool with me and showing me how to go ahead with it, right? So this course is actually designed in such a way that we try to get you clause by clause into a particular type of this thing. And I feel that right now learning the practicality of drafting has become a necessity. Back in law school, we did not have something like this, but this has become a necessity in today's world, right? What do you think, Gaurav, about it?
Yeah, I completely agree. Like in terms of practicality, these are things we do not learn in the normal course of events in a law school, right? And as I spoke before, that contract drafting is a practiced skill. It's something which you learn from exposure. And I think if I had Lawctopus's course or something like this, while in law school, it would have really helped me, at least in my internships, to be able to perceive what my senior wants and be able to give him more practical solutions. So definitely.
Right. Thanks, Gaurav, for that. So let me just quickly show you, okay? Obviously, all of us are wondering, is this course going to help me in my career or in any of my ventures or in my internships or job opportunities, anything? What is this course going to do to me? So for that, I actually have two special people out here with me. We have two of our past learners from our past batches of contract drafting course. So many people do the courses, but very few people take exceptional the skill set out of it and make the most of their time, right? So we have two of our learners from our past batches, Sabreen Ahmad, and we also have Shreya with us. Both of us received the highest possible grade in the contract drafting and negotiation course as well. So I would really request if Shreya and Sabreen could share a little bit of what they have felt about this course. Or let's quickly hear a line or two from Shreya as well. Shreya is from a very recent batch. So yes, hi Shreya.
Hi Akansha, am I audible?
Yes, you're audible.
All right. So hello everybody, good evening. First of all, thank you so much Akansha for having me here. And I'm Shreya Sajeev. I'm a lawyer and I've taken the course on contract drafting and negotiation in the month of July, August, which means I'm just done with the course. And I'm here to share my experience with you all. I was a little skeptical to start with the course, but I went ahead because the rating was really good. And now after the course, I feel that it was worth my money and time. And I'm just sharing an experience of mine. I had an interview with an MNC to the post of contracts coordinator a couple of days ago. Though I didn't have any practical experience in contracts, the in-depth knowledge I gained during this course reflected in my interview, and my interviewers were quite impressed, and they gave a really good feedback too. So to those of you who are looking for a job, I would definitely recommend you this course, and this is definitely going to help you a lot. And as Sabrina has mentioned, this course is an amalgamation of recorded lectures and live lectures. Recorded lectures are by industrial experts, like Bhuvnesh Verma sir and Loknath Chatterjee sir, and live sessions by Akansha ma'am and Kerima ma'am. They're really good, amazing faculties. And they're also provided with a book on contract drafting, and that book is very helpful. And let me directly move on to the part of my favorite part in this course. It's the contract lab. So we were divided into different teams and was asked to draft clauses to a given set of facts. And once we just done with the clauses, we were given personal feedbacks by the faculties then and there. And this helped a lot in drafting and also the assignments that are to be submitted towards the end of the course too. So in a nutshell, I would definitely give a 10 on 10 to this contract drafting course. Thank you. That's it.
Thank you, Shreya. Thank you, Sabreen. Thank you so much for sharing your experience. So I'm sorry, I'll just take up last 5 minutes since Sabreen and Shreya have really beautifully explained what is done. So I'll just in 2 or 3 lines, I'll just brief you through how the course is actually designed. As they rightly mentioned, it consists of reading resources. It has recorded lectures by industry experts, and we have live sessions. So in the live sessions, all of these clauses are actually taught practically, and all your queries and concerns are also taken up live, and everything is very practically done. It's designed that way. And 2 of the most fun activities and sessions that Sabreen and Shreya also mentioned is our contract lab and negotiation table exercise. It's like a dummy place where all of us pretend to be like lawyers and negotiate a deal together with our team members. And in contract lab, we are practically divided into groups, and we're drafting the clauses, and on spot we get the personalized feedback. We also have some master classes, like how you attended this session by Gaurav Mohanty. Even Gaurav will take up certain master classes. There are other professionals also involved with us, so that's also something that we conduct. Apart from that, we have a discussion forum. It's like a meeting place for all the faculty members as well as the students. So not just the faculty members, but even the students address each other's queries. So it's like a discussion going on, right? So that also brings a lot of learnings to us as well. I mean, although we are trying to teach and bring in more value, but then the kind of answers and the kind of things that we receive from the law students, first year law students, second year law students, and practitioners, it's brilliant. I mean, that's how it works. And we have a compulsory assignment which requires a practical drafting. So it's like a scrutiny and drafting of a particular agreement, and each learner's agreement is personally checked, and personalized feedback on each clause is actually given, not only on paper but also through videos as well. Then there are some career plan of action, like we gave a small teaser of how you can get your skills rewarded. We get into a little bit more depth of that in the course, and some, of course, add-on benefits. If you are a learner with Lawctopus Law School, obviously there are certain opportunities, and some we have a journal as well. So all your research papers and everything, of course, if accepted by the editorial team, also gets published. There's career counseling, but still, if you are unsure of what to do ahead, how to go ahead, whether to take up this course or not, or whether to, anything, even in general, if you are unsure, you can feel free to reach out to our career counselor. I've put her phone number also on the PPT. So you can reach out to her, you can note down the phone number, and you can reach out to her and ask about it. What I'm going to do now is I'm just going to quickly post in in case if you want to take a taste of this course, and if you want to register, I'll just quickly tell you how to do that. You can just go on the Lawctopus website, and you can just click on lawctopus.com, and you can see, if you scroll down, you can see this course, online certification course in contract drafting. You can scroll down and then click on this link. Also for Gaurav, I mean, it will be great if, he's put in so much effort, and he's simplified so many concepts so easily for all of us. And these are such complex, clauses which we, so how sweet, Gaurav, how sweet. That's beautiful. These are complex clauses which it takes so much time for us to understand each clause. I mean, after college I understood that after college is where your real learning begins. So each clauses actually takes a lot of time. So, bringing it into covering so many clauses in such short period of time, and that too so beautifully. Thank you so much, Gaurav, for taking time out for us. And we really appreciate all your examples and all your real life, all your movie quotes, and we really appreciate the amount of Hindi that you have tried to speak. So thank you so much for that as well. So okay, so with this we finally come to an end. There are any other queries or anything else that you want to say? I understand there are so many questions that are there on Q&A that we could not address, but we promise to get back to you with this. Any concluding remarks, Gaurav, if you want to just add in a line or two?
I think if Lawctopus does a PPT sharing class, I would love to attend that. I had a great time, and the whole idea of Lawctopus doing these practical courses for students, please definitely sign up for this, because it's going to really help you in your internships and ultimately in securing placements. I think Shreya and Sabreen have anyway given enough testimony and don't need to add to that. But as someone who did not have the benefit of these courses while in law school, I think this is a great and innovative step forward. So definitely sign up for it. And who knows, you might just get to represent Scarlett Johansson at some point of time.
Of course, with your guidance, Gaurav, I'm sure things can go really ahead for all of us.
I hope I get to represent her as well. So looking forward to it.
I'm so sorry, all of you learners. We have really overstretched our time. And I hope that it was a beneficial session for you. Now, I have spoken a lot. Gaurav has spoken a lot. Even Shreya and Sabreen, please just in this last 1 minute, I would like to hear from you how you have felt about this session. What was it? What was your biggest learning? Anything that comes to your head, we would really appreciate it. I would love to see some responses on the chat box. Thank you, Keshav. Thank you, Sumaya. Sumaya is saying, didn't know contract was this interesting. Thank you, Gaurav, for making it so interesting for all of us. Yeah, and Niharika says, being a first-year law student, this session was quite interesting. Would love to know more about it. Really informative session. Thank you so much. Thanks, Ria. Thanks for joining. Thanks for being so patient. We have, it was supposed to end at 5:30. We are at 6 p.m. and all of you are still so thrilled and excited to be with all of us. Mm-hmm. So thank you so much for that. And looking forward, I really look forward to engage with you more and interact with you more. I'll not
thank you guys for the kind comments which you've, I just went through all the questions. I wish I had more time. I already overstretched time and, stepped into Akanksha's period.
No, it's
amazing. And, thank you for the kind words. Really appreciate it.
I promise that we'll find a way to address all of your queries sometime. We will definitely find a way. Just keep yourself updated with the website also. Janvi saying, beautifully spoken. Thank you for the session. Thank you, everybody. And thanks a lot, Gaurav. Thanks a lot, Shreya, for joining in and for all of your time. Bye, take care, and stay tuned for more. Thank you.
See you guys. Bye.
Bye. Thank you.